Hello. Good evening, everybody. Hello. Is it?
Good evening. Good evening.
Yeah. Sorry for the delay. Should we start right now, or will it take little more time? Wait for little more audience. I think only 22 persons are there. As you wish, sir. We can give another 5 minutes. Mr. Das, Mr. Biswajit, Pradhan sir, namaskar.
Yes. Namaskar. Namaskar. Okay, we'll give 5 minutes more.
Okay. Mr. Biswajit is there already?
Yeah, I'm here.
Yeah. Hi.
We can take more time. No,
Good to see you. Actually, I'm meeting, but little delayed. 5 minutes more is okay with you?
all right. Absolutely. No problem. Okay.
Yeah. We'll start.
Yes.
We'll start now. Yeah. Good evening, friends. This is Mihit Sahu, Chartered Accountant. I am Secretary of Odisha Corporate Foundation. As you all of you must be knowing that this OCF, Odisha Corporate Foundation, is a voluntary organization. It's a society, a registered charitable society. Many organizations, many societies are there, many NGOs are there to give help to health, education, and other uh, services for the deprived of the society. But surprisingly, Mr. Behra came out with a novel idea of forming a society for the betterment of business community. As the name specifies, this is a community which handholds. This is a this is an it is a drive which handholds the uh, budding entrepreneurs, new entrepreneurs, those who want to do something, make their mark in the business. With that thought, we have got around 3,500 to 4,000 successful business entrepreneurs, business owners who are willingly, trying to help the new and budding entrepreneurs of primarily of Odisha origin. And in our endeavor, we have done so many mega seminars in Delhi, in Bhubaneswar. Last we had a annual conference of about 700-800 women entrepreneurs throughout Odisha. And our thrust was to give a mm, proper helping hand to the women entrepreneurs in the field of financing. And we always, this is like today's seminar, we have got a lot of webinars. We have already made a series of webinars in the recent past. And in our scheme of things also, we try to educate people on many subjects like this. So with this little background of OCF, now let's go to the topic, today's topic, that is PMLA, money laundering. This very name itself, it gives sleepless nights to most of the people, now in the in our country. So very difficult to understand the inroads of this PMLA. And Mr. Biswajit Das will speak on this, and Ramakant sir will also give an overview of it. To introduce, I'll have we are already delayed to give a little quick introduction. Mr. Ramakant Pradhan sir is the Field General Manager of Union Bank of India, and he is in charge of the entire state. Um, and Union Bank is doing exceedingly well in the state of Odisha. We hope that he also gives helping hand to Odisha entrepreneurs in future. With these few words, I present Mr. Ramakant Pradhan, who is our chief guest for this webinar. Coming to Mr. Biswajit Das. Biswajit Das is a fellow chartered accountant, and he has a very, very enviable and quite, I would say, it's an off-track career. He has, graduated in chemistry and then ventured into CA, which is one of the toughest courses in the country. And he passed that. After that, he was not satisfied again. He branched out to legal. So legal profession. And with all these background, science and accounting and this chartered accounting and finance background, he has developed a beautiful concept in arguing any case. He has a plethora of success story behind his kitty. And at the same time, his approach is quite different from other advocates. You'll find that he always, he's so confident. I'm here to find a person of his confidence in any profession. He says, from the word go, he says, yes, we are winning it. And that gives the solace to the, to the client. Okay, he's at least in safe hands. He will have he will have the last laugh once he goes with him. And he is the managing partner of Juris and Juris. He has got big clienteles like Jindal and many Orissa mineral sector people, they have consulted him. On PMLA. After that, we'll have a question answer session. Now I request Mr. Ramakant sir to give an overview of the subject. Thank you.
Thank you. Thank you, first of all, the Odisha Corporate Foundation who has given me this opportunity. And I also welcome Biswajit sir, who is a great orator having experience in all the fields as you have narrated. We'll be very happy to hear him. Prevention of Money Laundering Act, that is PMLA, is though a old subject, though the act came into effect from 2002, 25th August. But very little is known to people. Only it has come to the highlight when many people are arrested and many cases are filed. See, the act as such as a regulatory authority is being regulated by RBI, SEBI, and IRDA, whereas the enforcing authority has been fixed for the Enforcement Directorate, ED. So once the ED makes an arrest and it comes to the news, and when it came to the news after these amendments made in 2012 against whom people have gone to the court, and Supreme Court has given latest verdict where they have upheld the amendments. So this act has come to limelight so much. As far as bankers are concerned, whatever this illicit money that is being, or the laundering money, and they use the banks and financial institutions for all these stages. Normally, there are 3 stages of money laundering: placement stage, layering stage, and integration stage. And all these 3 stages, the financial institutions, the banks are being involved. In the placement stage, the entire black money, or actually the 5 offenses that are being considered under the money laundering are theft, fraud, bribery, terrorist financing, and tax evasion. So all these launder monies that come in the placement stage to the bank, either they are divided into small deposits in different small names, and they are kept in the bank. That is the placement stage. After that, they use it in different layers by making complex financial transactions. That may be, they may use different banking channels, multiple banks. They may use different currencies. Even they may open different fake or sell companies or sell accounts. And like that, again, this is the layering stage. In that, they go on rotating the amount. And finally, the funds are reintroduced to the economy as a white money, as a legitimate money. So the dirty money is being converted to white money through placements, layering, and integration. Now, the legal aspect, this is a criminal law, and how the criminal offense is created and how it is being implemented by the Enforcement Directorate, because they have been, the ED has been the mandated at the investigating economic offenses. Besides this, the ED, they have the power to investigate the offenses under Foreign Exchange and some other acts like Fugitive Economic Offenders Act 2018. Those who are those who have after the economic offense have fled away from the country, उनके लिए जो एक्ट है उसको भी ED enforcement करता है. कॉफी पोसा, that is conservation of forex and prevention of smuggling activities act, ये एक्ट भी ED enforcement करता है. So ED has the authority to deal with economic offenses related to money laundering, related to forex, related to smuggling, related to fugitives, the person who are leaving the country and going to some other country. So with this enough power with the Enforcement Directorate and the law that is being upheld by the amendments are upheld by the Supreme Court, there is a lot of things every corporate should learn, every student should learn, every research fellow should know, every banker should know. So to know all these details and the finer sections, important sections like those 45, where it is made the offenses to be cognizable and non-violable, all these things, our Biswajit sir will highlight. So I request all the participants and those participants from the bank also to hear him, because he is a great scholar with knowledge in variety of fields. Being a science graduate, he became a chartered accountant, then he became a Supreme Court jury advocate, and he presents case in a different way, and he gives a new direction to the jurisprudence, and his stature of person is available with us. I request all my colleagues, those who have joined, and the corporate candidates from OCF to get enriched with from the knowledge of Biswajit sir. Thank you. That's all from my side.
Thank you, sir, for a quick overview. Now I request Mr. Biswajit Das to take over the proceedings.
Thank you, Mihir Sahuji, for your eloquence presentation about me. It is your magnanimity of giving too much more than I deserve identity about me. But certainly, it is a great opportunity for me to really accommodate your audience here. I also convey my gratitude to the Odisha Corporate Foundation and his convener, Mr. H.K. Behra. And then I also convey my gratitude to Ramakant ji, who actually gave a very brief overview of the money laundering law. To begin with, I always have believed that this particular law, the prevention of money laundering law, though it is an act of 2002, but it actually was enforced in 2005 in UPA regime. Well, there is a lot of misconception about the money laundering law in India. And I have no hesitation to say this. And precisely for the very same reason, the very recent judgment of the Honorable Supreme Court, Vijay Madan Lal Chaudhary case, the dimension of the entire challenge before Supreme Court was CRPC, the criminal jurisprudence. Contrary to the perception and the knowledge about the PMLA, about what is the nature of the law is this is actually a combination of one civil and criminal law. It is not a purely criminal law. Number one, this is something very, very important for all people, not only the people who are governed by this law, but also those persons like me who appear in the court and assist the court. This is certainly not a criminal law. Let's be very clear about it. And this is also being reiterated by the Honorable Supreme Court in the Vijay Madan Lal Chaudhary. The very idea, the very fact that we believe that this is a criminal law, we commit the first mistake to deal with this particular kind of a law, which some people call it as a extremely draconian. Some people call it as a extremely devious. And some people call it as unjustified. But that doesn't take away the fact that this is a law of India. And it is as part of the international community. Let's give you a broad overview about this particular law. I think many of the people would be knowing about the money laundering law, but I will touch upon those areas which is actually not very well known in India. Remember, this is a law which I call it as a triple T. It transcends time and it transcends territory. So that's why we call it a triple T. It transcends time, it transcends territory. What does it mean? It means today the ED has power to prosecute even the Obama, even if he is beyond our jurisdiction. Number one. Second, it doesn't have a territorial boundary. Of course, India is becoming global player now, like America. Obviously, this particular law, which was enacted in the year 2002, post the 9/11 terrorist attack in the New York Twin Tower. That was the trigger point, a compelling trigger point for America to impose this law throughout the globe. That's the very immediate trigger point, though the international terrorism and your drug money was the trigger point for the entire global community as a political declaration through the United Nations General Assembly. They wanted to adopt this as a law. But ultimately, it is the 9/11 which triggered. So if you see the timeline, the 2001 9/11 attack, then 2002, it was enacted in India. Globally, all the countries adopted more or less similar design of law. And through this particular law, the America used to, take over the accused terrorists. Subsequent to that, 2005, this is the act which was actually enforced in India, though it was enacted in 2002 by Parliament. It came into enforcement in 2005. Pursuant to that, this law has gone through a series of amendments. And as you all know, in fact, the proponent, the enforcement, and the enactment of this law, those people who were the parliamentarians, today they are being prosecuted while in 2019, 2021. And let me tell you, this is such a kind of a design of law, a composition of criminal process and civil process, that it covers all as a potential money launderer, except the ED records in reasoning and writing that yes, he is a money launderer, or a proceeds or a property is a proceeds of the crime. So this sum and substance of this law is, I think there is some echo is happening. May I request the listener, because I would request all the members who are hearing this, I'll be in a much more comfortable positions to interact and answer the question, because there is a lot of misgiving about this particular laundering, prevention of money laundering law. So when I talk about this timeline, beginning from 2001, then 2002, and then 2005, and now we are in 2022, the money laundering law, most of the people believe is a criminal law. It is not. It is civil and both the criminal law. And it is also reiterated by the Supreme Court very recently in the Chaudhary, Vijay Madan Lal Chaudhary judgment. And how it is, I'll just show you a small slide for you. I may request Adabika to give you a particular slide to understand. And before she gives you a slide, I'll tell you that about what I talked about, that it transcends time and territory. As I told you, that it has no territorial boundary, and it has also no territorial, it has no time. My grandfather's offense, alleged scheduled offense, today I can be prosecuted today after 50 years. Same way, my actions of alleged scheduled offense, my grandchildren can be prosecuted. So it has no time limit. And precisely for that reason, even the ex-finance minister, Mr. Chidambaram, for his alleged offense of 2007, he was prosecuted in 2019, one jailed inside, and still he's an accused person while we're talking about 2022. So there is no limitation on time. There is no limitation on territory. This transcends everybody, except the ED has to record a reasoning. And on the basis of a material or on the basis of the information, and the information and the material on the basis of which the ED has to record his reasoning, that yes, it is an offender of money laundering. That is certainly is extremely shallow as we speak, because it has no barometer as to what should be the parameter on the basis of which the ED can form its opinion. And except to the extent in the law, which says that if somebody is being prosecuted or being jailed only on the basis of non-recording of a reason, the ED officers can be prosecuted. If they record the reasoning, that cannot be questioned. So in other words, the entire population of today, yesterday, and tomorrow are under the clutches of the ED, within the jurisdiction of the PMLA, with the simple inscription by the ED stating that I have reasons. I think there's some disturbances happening. May I request the audience to be kindly mute their mic so that I can uninterruptedly give you a small overview, and so that we can go for an interactive session. All right, thank you so much. So, no, there is a slide. There is a slide which goes to show. There is a slide which goes to show the 3 offenses, that 4 offenses. Slide. Devious. To give them their overview about how the scheduled offense and how the proceeds of crime and the thereafter. I told you to keep it in readiness. That slide we got it that 4 circle, right? Offense. Yes. Now look at this. I have prepared one slide for you. And because the time is difficult, because this law is extremely difficult to decipher, it's a complex from out of its complexity, the time has come to present everything in a graphical way to be able to get a clarity about the subject. Now here, in a particular, the slide is divided in 2 colors. One is a blue and one is a slide, the slide yellow is color, which in other words, I say that the blue color slide, the background color blue is demonstrating it's an offense under the various statutes, which otherwise is called as a scheduled offense. Like for example, Indian Penal Code, like for example, Customs Act violation, Companies Act violations, copyright violations, COFIPOSA violations, all these statutes which an offense can be committed by a person if it is prosecuted under that offense is called as a scheduled offense. That's a criminal prosecution under that particular law. That is called as a, I have shown in an ecliptical a feature where it is shown that the scheduled offense, SO, that is the schedule of the PMLA, and this is an offense under the criminal prosecution. This is one prosecution for an alleged action of yours. You can be prosecuted under one law. Whether it is, for example, it is a customs violation. If you have committed an offense under the Customs Act, then this offense prosecution is called the scheduled offense, and the prosecution may be carried out by the respective agencies under that particular statute. But when it comes to a proceeds of the crime, that is something which you derived, a money, property, value, whatever, which is derived, obtained from that scheduled offense, then that becomes the proceeds of crime. So for every alleged offense under any special scheduled offense for which you will be prosecuted, a money is generated, whether in value or in property, that becomes the proceeds of the crime. So that proceeds of the crime, the state will, the central government will enter into it and will prosecute you for a confiscation of that particular proceeds of crime, which is called the civil prosecution. That is where I say the prosecution of confiscation of the property derived or obtained from the scheduled offense, that is the criminal offense, will be prosecuted by the central government under the PMLA is called the proceeds of crime. This is the second proceeding. The first proceeding is the scheduled offense proceeding. This is the second of prosecution, that's a civil prosecution by the central government under the PMLA of the proceeds of crime. This is the second prosecution. Then you come to that proceeds of the crime, confiscation activity, a proceeding will be done by the central government through the ED is a civil prosecution. So the moment there is a criminal prosecution happens, the ED can step in and initiate a civil prosecution for a proceeds of the crime generated from the scheduled offense. I hope you understand all my dears. So these are 2 different prosecutions. One criminal prosecution under different law, under special separate law. And the second prosecution, which is called the civil prosecution for attachment and then the confiscation, attachment of the property and then confiscation and vesting in the central government of the proceeds of the crime. That is the property derived out of the scheduled offense is the second prosecution under the PMLA. There is another third prosecution happens. The moment that proceeds of the crime is being laundered through a process and activity, then that becomes another offense under the PMLA, and that offense is called the money laundering offense, which is given at the right orange circle. So in other words, if you cheat me, because you have cheated me, because you have defrauded me, therefore it is an offense under the Indian Penal Code. That is the scheduled offense for which the local police will initiate a prosecution under the local court. That's the first offense. And the money derived out of it, which is the proceeds of the crime. Why? The proceeds of the crime can be confiscated and vested in the name of, in the central government. Look at the peculiarity. 2 parties may be defrauded to each other. A prosecution under the IPC will be initiated by the local police, but pursuant to that, the RED can step in and ask for the proceeds of the crime arising out of the illegality and can confiscate it and attach it and confiscate it in a civil prosecution under the PMLA. That's the second prosecution. When that proceeds of the crime, if it is possessed by somebody, used by somebody, concealed by somebody, or possessed by somebody, or painting it as an untainted property, or it is claiming it is untainted property, then that is an activity of the process. The very activity of process, which is continuous in nature, is a third offense. That's the money laundering offense. So there are three, for a one action, there can be three prosecution. One is under the respective statute, which has, under which a particular person has committed an offense. Then there will be two other consequences under the money laundering law. That is second, proceeds of crime, that is attachment and confiscated. And the third one is the money laundering, which is criminal prosecution. So it effectively, one of your alleged wrong action, even if it is not being proven to be so, and it is under the process of investigation and prosecution and trial, you still have to suffer additional to prosecution. One is a civil in nature, that is called the attachment and confiscation. And the third prosecution under money laundering in a special court, under the money laundering law, by the central agencies. So in other words, you will be prosecuted twice for the same action. And the property arising out of the scheduled offense, even if it is a private property, this will be vested with the central government. Look at the peculiarity of this law. And that is why I say this money laundering law is not a criminal law. It is a combination of the criminal and civil law. And there are two agencies which operate. There are two entire mechanisms operate for prosecution of these two different sort of actions. One are the proceeds of the crime, and the other is the money laundering crime. So these, and the money laundering offense is a continuous offense, because every second is a new offense. Every second, suppose 1,000 rupees or a lakh, suppose for example like 2 crore rupees as a proceeds of the crime generated out of the scheduled offense of a fraud, then that 2 crore rupees, as long as in your possession, every moment of possession is a money laundering. Every moment of uses is a money laundering. The moment the money hits to your bank account, the fact that it is in your bank account is a money laundering offense. Unless the onus is anew, the innocence, presumption of innocence is actually inverted. This is a kind of a law which has all the devious elements together. Now, when I say there are three offenses, there are also the fourth offenses under the money laundering law, which I have shown it in the bottom, under section 50, 62, and 63, linked to this particular action, where for a one action, there will be 4 prosecutions. One will be local agency, and the central agency ED will be for 3. But yes, the moment money laundering law steps in, all the prosecutions will be handled by the central agency. And therefore, first of all, we must understand that this is a law which not only pertains to the scheduled offense, which currently have 29 paragraphs, 29 statutes under its schedule, and other 2, which is under the Part B and Part C. And these schedules are getting added every moment. I think there are some disturbances. This schedule to the money laundering law gets added every moment. And ironically, some of the time, even through the Finance Act, that is the money bill route. That is another angle of a challenge which is still pending before the Honorable Supreme Court, as far as this particular legislation's amendment happened through the finance bill. That's a very typical argument. Of course, that will come up at a later stage. Currently, the virus has been thwarted by the Supreme Court on all grounds. But those virus challenges happen through a very, according to my, with respect and with all my humility, I say that the challenge before the Supreme Court, when its virus was challenged, was certainly not in a correct dimension. because the entire universe of challenge was rested on the CRPC rule. That if CRPC says this, why can't the PML also should have this? Now the question is, if this is a special law, Parliament made a law CRPC, Parliament also made a law PMLA, Parliament prescribed a procedure under the CRPC, A, there is a B procedure prescribed under the PMLA. Can we question that just because CRPC says A, the PMLA should also have A in order to sustain its constitutionality? And that precisely is a wrong dimension of challenge as far as this particular last attempt, its virus challenge in a holistic way, the Vijay Madan Lal Chaudhary. That's point number 2. Now, point number 3, I wanted to tell you that this law actually treats all of us as a potential money launderer. Whether you are honest officer, whether you are honest citizens, it doesn't matter. What matters is that the ED will write in writing, it will also give only reason in writing that yes, you have committed an offense of money laundering, and that it is only an assessment on its own, and that is not questionable in any court of law. That means tomorrow's X transaction happened in my account, and that transaction is picked up by the police, the ED, and says that it is related to the money laundering offense, and therefore I prosecute you. And the entire trigger of the PMLA process begins. And let me tell you, this PMLA has combination of all jurisprudential inversion. Number 1, the moment ED forms opinion that yes, I have reasons to believe on the basis of the material before it, and what is the component and the weight of that material, maybe bank statement, maybe some books of account, maybe some property details, some transactional elements. That's all. Because as we all know, no property, no documents, no paper itself inscribes about its status as to whether it is laundered money, whether it is ill-gotten money, whether it is pertaining to any criminal activity or not. But it's just this assessment of the AD that triggers the entire universe of a criminal process and civil process of money laundering law. Now, by this logic, and what is the safeguard against it is that Section 62 talks about if the ED begins a prosecution under this law without recording the reasons, only then a prosecution can be triggered against that officer. And that too also, the prior permission for prosecution has to be obtained from the central government. Just look at this designing. These are not certainly argued in the courts till date while challenging its virus. And I tell you, I ask myself whether when we talk about the criminality, a person's criminality on the basis of its records, bank statements and all, or a statement written on a piece of paper or somewhere, as a mark of evidence on the basis of it, the ED will trigger this process. Now tell me, something I write today in a piece of paper, seen from a different angle by me, I may read it differently, right? Now, all of you, most of you are chartered accountants. You file the returns on the instruction of your clients. Now, tomorrow, the ED can come on a particular transaction and they say that, look here is a violation of the income tax law. If it is a scheduled offense, then obviously the ED has an exclusive right to enter into it, initiate the attachment proceeding or proceeds of crime, and initiate also the criminal prosecution of money laundering before a special court. Purely on the basis of a visible assessment of a document which can't speak for itself. And peculiarity is, any document obtained from your custody, or for that matter, you have given it to them on their request in a Section 50 inquiry proceeding. Anything that comes out from you, it will be presumed that the content of those records, papers, documents, etc. are true. it will also be presumed that you owns that document. It is also presumed that any handwriting content of that document is your signature. It is also presumed that it is executed. In other words, what means that nothing is to be proved by the ED. It just has to be presumed through the statutory policy. It is proven through the statutory policy, and you have to prove your innocence by disproving the statutory presumption. Now the question is, when a money laundering by mere possession is a money laundering, how do you counter, how do you dislodge the guilt presumption? And in the event where the onus is entirely on you, not on the prosecution, but on you to disprove your innocence. You will have to prove your innocence because you are guilty presumed. Your guilt is presumed under this law. That means the entire elements of devious legislative policy are clubbed in one place. Mind you, this is that law. This is the first in the history of law. Just remember, it's very important that this is only one law for the first time in the history of a civilization that entire jurisprudential concept has been inverted against that. The burden of proof is inverted. That means the moment the ED says, you have to disprove what ED says, you are presumed guilt. Therefore, the inversion of the presumption of innocence, a criminal jurisprudence is a very established criminal jurisprudence, because in any criminal prosecution, presumption of innocence is inbuilt, unless in some cases, in heinous crime cases like Tada, Mkoka, where presumption of innocence is inverted, but that only happens on one content. Here, the entire inversional jurisprudential concepts has been clubbed together at one place. Burden of proof is inverted, presumption of innocence is inverted. The entire proceeding will begin with the ECIR, the enforcement case information report. It is even given in the sealed cover. You don't have even the access to the content of it. So that means the entire ED will initiate the process of attachment as well as your money laundering case through a sealed cover. You would not know what the contents of allegation against you. There is also a self-incrimination. Importantly, it's the most important part, is the section 50 of the PMA. What happens? ED calls randomly. And then it says that tell me the truth, otherwise we will prosecute you. And when it was challenged in the Supreme Court through Article 20, Clause 3, which says that no criminal person shall be compelled to give evidence against himself. What this section 50 does is exactly the same. It incriminates, it asks you to come, then you will be told that you have to tell every truth. Otherwise, there will be another round of prosecution will happen, which I have showed you in that particular graph, the bottom of circle, which talks about the other prosecutions, non-money laundering prosecution under the money laundering law. So it is self-incrimination from arising out of section 50. Unchallenged, because as we see that there is a protection against the self-incrimination against the accused persons. No person accused of any offense shall be compelled to give evidence against himself, is actually the Article 20, subclause 3 of the Constitution. It's a part of a fundamental right. So this is also a self-incrimination protection is there to an accused. But ironically, the judgment of the Honorable Supreme Court went on to the extent of saying that because at the section 50 inquiry stage, where you will be called for an inquiry, not as an accused, you are not an accused at the stage of section 50 inquiry. Therefore, you do not fall within the ambit of section 23, as if the fundamental right is a charity on the part of the Constitution. And therefore, you, in order to get a protection of fundamental right, you need to come under within the perimeter of the language of all the articles under the Part 3 of the constitutions. That's a very inverted argument. Unfortunately, that's the jurisprudence that we all know. Certainly, in days to come, we will be able to develop a law, get that sanctity from the Honorable Court, that look here, the Article 23 protects even to an accused. That's we the people of India has given these protections to us, cautioning the institutions, the state, not to trample to our fundamental rights, which are our natural rights. And therefore, if the threshold of 23 protection is applicable to an accused, how can the state would dare to make a legislation through parliament to say that you are not an accused and therefore the protection of Article 23 is not extendable to you? I ask this question myself. If we, the people of India, have cautioned through Article 23 saying that, look here, do not even trample the self-incrimination principle against the citizens, and if you are the accusing entity, the prosecution entity, the onus is on you to prove his innocence. You cannot force him to give evidence against himself. How that principle will not be applicable to Section 50 of the PMLA? It's just because the jurisprudential development in India, as I speak, is certainly not developed in that line. And in days to come, we have to ensure that what is correct and this institutional anathema cannot be entertained in this manner. Just because, for example, I just ask you this question. I, in my house, appoint a guard giving the responsibility to protect my security. The guard borrowing the power of security of me, from me, creates a cell at the gate where he is having his cabin to protect the house, and say that all the occupants of that house for whose safety I am being engaged, I will put you in a lock and key in front of me so that I'll be in a better position to secure you. Is this not similar to that? Just because there are terrorism, just because there are ill elements in our society, can this be a reason to legislate a law to treat every citizen as a potential offender? And then the state will give on giving certificates as to whether you are an offender or not? Is this not an inversion of the governance? Now, for you to ponder on this, while for us to develop the jurisprudence to tackle this problem. Because with every passage of time, getting emboldened to this kind of a legislation, the government of the day will bring more stringent law, which to some draconian, for others, it is impossible. But yes, it is our responsibility to protect our interests, provided we will have to also develop a mechanism to prevent this ill elements of the society. There can be a different model, but to create a model of screening of this nature, which is nothing but a roving inquiry, this is certainly not part of a civilized society's democratic institutional discourse. Anyway, this is the fourth important devious element of this legislation. And importantly, there is also an infringement of the federal structure here. Look at this, what this design of law is. We all know that the law and order is an issue of the state, and that is exactly the division of role and territory of all the different institutions. And here, the state, the central legislation is made, and where a IPC offense, where the state has exclusive jurisdiction, will be resuscitated through this section 44-45. Now, that is again is another aspect for the different state entities to look at it. Now, look at this entire process. That itself is a punishment. And here, importantly, he has an absolute jurisdiction, unwavering jurisdiction. Then the government is becoming the complainant, informant, intermediary, investigator, and prosecutor, like what Mr. Pradhan stated. The Ramakant said that they are the intermediary and the bank. The banks are the intermediary, through the banks, the information is percolated to the government or the ED, and the government will pick up that information and will, in other words, what I indicate to that, if you see the entirety of the design of this law, the government has become the complainant, at the same time intermediary, at the same time informant, at the same time investigator, at the same time prosecutor. And when it comes to the court, it has withdrawn the power of a bail, granting a bail from the court. If you see the section 45, the twin condition of section 45 of this particular statute, where it has completely, virtually withdrawn the power of granting bail from the court. Because to grant a bail, the court has to take the permission of the public prosecutor. If the public prosecutor refuses to grant a bail, then the court will have to form opinion that yes, the person is not guilty of offense of money laundering and that he will not commit in future that particular offense. Can you imagine? Can a court say that at the initial stage? That yes, the person is not an offender of money laundering? And second is that he will not do it in the future? Virtually, this is nothing but a language gimmickry. And this particular language is actually declared ultra vires by Nikesh Tarachan judgment of 2019. But now that particular judgment has been deferred by this particular very recent judgment of 2022, the Vijay Madan Lal Chaudhary. Now, of course, that element is still left wide open for the decision at a later stage. So what I'm indicating to you, this is another devious element of this particular law. And then there's a lack of judicial oversight because in any case, this is a transactional issue. Please understand, ordinarily people believe it's a criminal offense and therefore they by and large try to argue from the CRPC angle or the criminal jurisprudence known to us. But believe me, when you commit an offense of the mining law, when you commit an offense of the, for that matter, environment law, when you commit an offense of the income tax law, which are those laws? These are specialized laws. There are specialized people like chartered accountant and other people who understand that particular compliance laws. Now, when that offense is committed there, now you don't apply in order to understand the criminality of the scheduled offense or a predicate offense, you need to have a clarity about that branch of law. Now, when you are going and defending a case before the special court for the money laundering offense, or for that matter, the proceeds of the crime, now what you need to understand is that there is a predicate offense. Only when there is a predicate offense and the proceeds is generated from out of that particular proceed, the predicate offense or scheduled offense, then that proceeds of the crime, when gets laundered, processed, activated time and again through possession, use, and your concealment, etc., then only the money laundering will offense happen. Now, in a trial, you need to have a substantial knowledge about what constitute the offense of predicate offense, like mining law offense. Suppose there is an offense called section 21.5 or 21.1 happens, that somebody without the authority of law raises a mineral from any area. Now that is something has to be understood in the context of the mining science. And I think many of you would remember that the Honorable Supreme Court judgment of 2nd of August 2017, where the common cause case, where the Honorable Supreme Court has declared a violation of the environment law, violation of the Forest Conservation Act, violation of your Air Act, Water Act, etc., are treated as a unlawful activity and thus penalize 100% compensation under section 21.5. Even though parties have already paid that amount, and then they wanted a deduction under section 37 of the Income Tax Act, that was disallowed through scrutiny assessment. Then 148, I mean, the series of consequences emerged out of it. Now, currently, that particular action is also being prosecuted under the money laundering law. Now, there's no respite to it. So what I'm indicating to you is this, that the entire dimension of this particular law has to be understood in the context to be able to address its problem. Every problem comes with a result. How much time has gone? Okay, now I think ask how much time I have, because then we have to leave it to the members to...
Yeah, please continue for another 10 minutes.
All right. So what I'm indicating to you that this is a particular law. Everyone in India need to understand that this law is not an ordinary law. This is the first in the history that every jurisprudential devious element has been clubbed at one place. And believe me, when this particular constitutionality was challenged before Supreme Court, interestingly and ironically, with the due respect and with all my humility, I say this, that the judgments were cited individually for justification for all these inversions separately, never being addressed to the kind attention of the court, never been brought to the kind attention of the court that, look here, this is a legislation with all the jurisprudential devious elements are clubbing together once, need to be examined completely afresh, not influenced by any judgment, for that matter, on the ground of the compelling state interests. Because we know MCOCA, your for that matter, the UAPA Act, these are the legislations, they have small and some elements of these devious elements there, but not in a totality, not in unison, not in wholesome. But each of this jurisprudential identity traced in this particular law is justified by driving one judgment after another, not realizing that there is an interstate effect and relation. And that makes this law constitutionally impossible. Can we create a situation? Is it not akin to a kind of an emergency where the moment the ED will trigger the PMLA and take you to inside the jail, the court doesn't have a power to grant bail, except to the extent that you will be only given bail under section 436A of the CRPC, where if you will be undergoing an imprisonment for at least 50% of the maximum punishment, like for example, in this case, PMLA maximum punishment under the PMLA today is 7 years, and for customs offense is for 10 years. Sorry, that is under the 10 years is for, I think, no, this is the 10 years is for PSC, drug and psychotropic substance. That is under the NDPS. This under section 4, the punishment is prescribed 7 years for all kinds of money laundering offense, except one category that is called the NDPS, for which the maximum punishment is 10 years. Now, if you are inside the jail, then you will only be released by a default through a statutory measure of section 436A of the CRPC, where at least the minimum 3.5 years or 5 years you are already inside the jail. Look at the devious element. The court even doesn't have a power to grant you bail. The executive will become the prosecutor. The executive will be as a form of intermediary, as a form of informant. They will be initiating it. They will be the prosecutor. They will be the investigator. They will be the denier of your bail. Power to grant bail is withdrawn. Onus is on you to disprove and prove your innocence. The entire ACIR will be in a sealed cover. You will be only given some information about it. You would not know every content of it. And thereby your right to defense also is being trampled. And again, you are through a section 50 prosecution, that is inquiry proceeding. You will be asked the information and you are supposed to give it, and that you will be forced to incriminate against yourself. And how? Who on earth can read from a document and will form an opinion that somebody is committed an offense of money laundering, but that kind of a power is given to the ED? Now, whether the entry 97 of the Union List of the 7th Schedule, which gives the power to the Parliament to make the law, which is called as a residuary power to make the law, whether extends to a possibility where the state becomes master and the master becomes from whose it derived the power to legislate, we the people of India, as the preamble to the Constitution, that they exercises the power from we the people of India to legislate a law for us, but they treat us as a potential offender. On the basis of what? My books of statement, my bank's account, my money deposit somewhere. Now, can this be a sufficient ground? Can this be a ground to initiate or trigger a criminal process without somebody third party involved in that? Have you ever heard about any particular criminal prosecutions in any legislations for that matter, where without the involvement of a third party, independent of the government, without a complaint, except those cases of a compliance cases like Companies Act, where the special persons will be authorized person will be appointed for making a complaint to the magistrate, except those compliance cases. When it comes to the non-compliance criminal cases, element of criminality, whether can be fastened and triggered, and a criminal process under the PMLA can be triggered, that's as a part of a design of the law. Without the involvement of the third party, can such a legislative discourse be ever contemplated? Though it is staring us, have we examined it from that point of view? Have you ever tried to understand from that point of view? I always call it like this. 2022, Chinese sophisticated weapons. India is going and defending with a 1947 armament to deal with this sophisticated Chinese weapon. It's just like that is happening. A design so complex, a design having culmination of all devious elements in one place is being handled through solitary weapons having no interrelation to each other. And then what? From an angle of CRPC. And the Honorable Supreme Court, to the extent of the argument presented before the court, has rightly stated, by invoking the purposive construction and telling that there is adequate safeguards. What are those safeguards? Even when we talk about the safeguards, to the extent saying that the highest ED officials are involved to trigger it, I don't know how many of your viewers will be willing to give that kind of a power to an authority, howsoever high and mighty he may be, that he will become our God. So this is one angle of a critical element of it. The second element of it, that from the point of view of what Mr. Ramakant ji has stated, this is every suspicious transactions, it's also defined. If you see the suspicious transaction, here, interestingly, any transactions to a person which may appear to be a person, acting in good faith, appear to be that it is involved in this. That means any authority, whether a bank, financial institutions, or any intermediaries, any employees, which just applying his thought, if a particular transaction is suspicious in nature, that it is involving the terrorism, financing and all, I wonder how, barring the cases of a terrorism activity, I can understand this particular legislation as originally designed for the terrorists and the drug money, your transnational impacts and effects. But how come this particular legislation authorizing on the ground of the transnational effect be justified on ordinary citizens? And when it comes to a proceeds of the crime, even for a cheating case, that proceeds of the crime will go to the vested with the central government. When there are, I can tell you there are numerous fault lines in this particular law, and in particular the complexity with which it is designed. If we will be able to decipher that complexity in a simplistic possible way, then perhaps we will see the ray of hope at the end of the tunnel to be able to get over these particular legislations, because no civility can sustain with this kind of a law, howsoever corrupt society we may have, howsoever difficult elements may have in our society. Treating everybody with this level of shallow defenses, with the shallow cross checks and balances, which otherwise has no merit to stand on its own, sustaining this kind of a legislation is certainly not a very happy position as of today. I also sometimes feel bad that the officers of the ED forming opinion on the basis of the entries. I wonder, for example, a company law non-compliance, a ED officer, without having, as we all know, that how complex the company law is, how big the volume of law is, Now, you will see interpretation of some component of the text. You will see one judgment. You add another provisions of another law, you get another outcome. Now, with this complex element, the ED will initiate the money laundering process on the basis of the non-compliance of a particular specialized law. Apart from the fact that we, the lawyers, may have a harrowing time in the court to understand that special law and its impact on the money laundering law. The ED officers are also, and that is the reason why we always have seen that the ED officers used to ask hundreds, thousands of, they used to pose 100,000 cases, questions rather, for a particular accused person when they invite, and they interrogate for days together for a 16 hours, 18 hours. We all have heard it from the news. I think all our viewers understand that. But how? Why they are actually interrogating so much? Well, that's very complex. It doesn't work out this way. It may be utopian to think that, okay, we'll have one wand and can really be used and really remove all kinds of miselements in our society, from our society. But this is not the design of the PMLA. This design of the PMLA was done in the cross-national implications of organized crime, of drug money and terrorism money. And there will be a crisis where this ED could have exercised this power under the PMLA. But today, without the boundary, creating a boundary, this legislation is taking within its fold the entire population. I call it as the entire 8 billion population of the world is within the thumbnail of every enforcing agencies under the PMLA law of every country. I wonder if anybody can disagree with me, but these are the practical assessment of us. And certainly it is going to give us a harrowing time to even deal with in court. Can we imagine that we all know that the coal block illegal actions of 2013, when the Supreme Court in your MK Sarma case has declared all those coal block allocations and directed for a CBI investigations. Do we know this 2020, all this prosecution is still going on? And post that proceeds of the crime, now that prosecution again go on. As long as the proceeds of the crime, even a single penny is left out, as long as that single penny is in your pocket, getting used, or even in stocked in your closet, that is also a money laundering. That means, in other words, even ED doesn't have a power to exonerate you fully. It does give you one assessment judgment on a particular case at a particular time, but it does not give you absolute exoneration, because he will form opinion on the basis of an assumption, on the basis of visual examination, not on the basis of judicial assessment. And that is precisely the reason this law, according to me, is impossible law, and it is an affront to the civility. And I must say this, people like you must understand this and should really carry this touch to even the executive, to say that, look here, even though your objective is so humane, but the end result is not that easy. End result is not that going to be any matter better. Rather, this is going to create a more problem. We do not have a judicial infrastructure to deal with it. We do not have an intellectual standing to really deal with it. We may be trying to capture few international syndicate elements. And that is where I say the solution lies in knowing the problem. And I request, if the floor can be given to the audience and they can ask any question, perhaps to test what I believe to be true, judicially, jurisprudentially, may not be so validated by the court as yet, but that's how we have to develop the law. This PMLA is a conceptual, it is completely different law. Let's then examine it in a different angle. We cannot be using the old weapon to really deal with a new sophisticated weapon like the PMLA. So I request your audience to can really come up with any questions.
Thank you. Thank you, Mr. Biswajit, for showing us the Diwali firecrackers just before Diwali. And Well, I have a couple of questions to start with. My question is, since bankers are also there, my question is, there is a in any lending there is a concept of end user fund. So if that is not satisfied, in many cases, that happens. They take and they invest in some other properties and not for the purpose for which they have taken. So in that case, also squarely this law can be applicable. So this might help the bankers uh, through PMLA to collect back, get back the money. This is one question. But as you said, as you raised the concern that in this process, I feel all the literate people, literate citizens of the country can be possible offenders.
Yes.
That includes the lawmakers also. If the lawmakers in a country, legislatures, lawmakers in a country also, presumed to be offenders, then the entire country becomes the country of offenders. So this way, a country cannot, you know, prosper. Anyway, so now the floor is open. Anyone wants any question? Mr. Das has offered to answer all questions. Over to you, audience, please.
As far as PMLA is concerned, I think so far no bank has proceeded against any defaulter against PMLA.
Now what Mr. Das has told, I think this could be one of the best weapons to proceed against. Your views on this, Mr. Das?
Okay, let me tell you, the PMLA as a law is under complete control of the central government. So no banker, no one else can make any complaint, and it will not automatically take in cognizance of. The cognizance of this.
No, now since they are writing to CBI for any case, any such cases, they can also write to ED to pitch in.
So unless and until ED takes cognizance of, the money laundering law cannot kick in. Number one. Number two, the money laundering law, as far as the bank is concerned, irrespective of whether the bank approaches to the ED or not, it remains within the exclusive jurisdiction of the ED. As I told you, it has an absolute jurisdiction. It can pick up anything of your choice, of its choice. And therefore, it is not within the control or command of the banker. Yes, banker may intimate, or for that matter, if there is a two defaulting party, if one is alleging the other person as a 420 case is going on, the ED, unless takes cognizance of, no private party, including a banker, has a no role. So therefore, it is ED absolute jurisdiction. Number one. Number two, as Mr. Sahu, Mr. Mihir Sahu has asked, that there has to be an end user. Let me tell you, this is a kind of a law which has to begin not on the basis of a conviction. This is a law which is triggered by the ED on the basis of its own assessment. The only criteria for a triggering of this is recording the reasons in writing. Now, what material is before it to form opinion? What information is with it to form opinion is a completely in-house affair of the ED. And as I told you, the ECIR itself, at the time of even the registration, remains in a sealed cover. So in other words, this form of governance, let me tell you, Mr. Sahu and Mr. Pradhan, these forms of governance, at least as a law-abiding and law-practicing entity like me, is certainly not very happy thing to say. Because after all, then what is the purpose of the court? The citizen is empowered for a redressal of the grievances by going to the court with informed actions as to what defense it may take. Now, if it will go to the court and court, it cannot form any opinion on the basis of this, yet they can give it to the court in a sealed cover for the perusal of the court. Then what is the form of a jurisprudence? What is the form of adjudication is this?
Dasar,
Yes.
एक छोटा सा जैसे आप बोले ना ECIR, that is enforcement case information report. It is as good as FIR. In case of a criminal case, we will file FIR. Before arresting somebody, we give a copy of the FIR. At least you can know what is that. But in this law, even ECIR will not be given. So we cannot know why you are arrested also.
No, just Mr. Das, just a little supplement to your questions. I see, although this is a draconian law, I see a silver lining in the cloud because ED, they are just presuming that there is a crime. But when a banker gives them with all the facts and with all the forensic audit reports, then ED has got a valid reason to proceed against. So that can be a possible tool. I mean, that will be a strong tool for the ED to win before the court also. So why not? This is taken as a tool by the bankers, and the bankers are also central government owned bankers.
You see, PMLA, just see the PMLA on the two front. One is the international syndicate terrorism as a ground which justified the bringing this law onto the ground. Correct?
Yeah.
This is the ground justification. A law was brought to us. Correct? Now,
right.
This law, now what they are doing is that this law is extending to any compliance issues, including cheating, fraud, the bank default case, etc. Correct? Now, let me tell you, for a non-compliance, anything which is involved in relation to non-compliance is a proceeds of crime, and the state wants to take over confiscating itself and wants it to a vest to itself. Can you imagine? Now, you talk about the banking. Now you talk about there is a forensic audit and all. Let me tell you, where is the forensic audit operate? See, forensic audit is also being mandated under your IBC, Insolvency Bankruptcy Code. Okay, forensic audit is also there under the Companies Act. Am I right?
Yes. Even the bankers are independently, they can do.
That's right. No, I'm only giving the statutory framework. I'm saying that where is the statutory framework for the forensic audit? One is under the Income Tax Act, one is under the Companies Act, and another is under your IBC. Correct?
Yes.
Beyond that, there is no forensic audit mandated under the law. Correct? And all these things are with respect to somebody's money being taken away. Like bank's money has been siphoned up, therefore the bank wants it. Income tax law, because there is a income tax of the government is taken away, therefore there is a forensic audit. IBC law, because the shareholders' money being taken away by the management, therefore the forensic audit, right? So this is a way to retrieve the money for the rightful owner. Now tell me, where is the money laundering law? Where is and when there are different agencies operating under the specialized law? Now suppose for that matter, if a cheating is being prosecuted under the JMFC case or a magistrate, metropolitan magistrate first class. Now, will he not even trace that money where it has gone? Then do we need another agency? And that agency can't be the state agency, it has to be the central agency. And what infrastructure it has?
Yes, that is the question.
What infrastructure, what judicial infrastructure do we have in our country? Today, only 2-3% of the population are accessing to the courts. Imagine what is happening, that every transaction is a potential offender can become. Today, the ED's entire hands are full with the existing cases, right? Now, if there are adequate capacity, the ED can go after the entire population. Now, where we have those jurisprudence, where we have a judicial infrastructure, where we have a knowledge, where we have those, and what forensic audit are we talking about? Are the EDs are so competent even to understand what the technology, the accounting jargons and the specialized elements? For that matter, an offense under the Coal Act and the offense under the mining law, and then they will examine it under here, and then whether they will count only the money or they will count also the offense, predicate offense. Are you getting my point?
Yeah.
And then selectively prosecuting through ED only. So therefore, what I'm indicating to you, this is a law meant for a particular purpose. This is a law which was justified for a particular purpose. You need not have to extend it. What is happening? schedule is getting added. Every schedule, new laws have been added to it. The moment that law schedule gets expanded, then the money laundering get expanded. In other words, the central agencies is going to take over the entire criminal justice system of the country. Then for what for the state agencies are there? What for the state governments are there? They may be inefficient. We have to make them efficient. But then why the citizens should be made a scapegoat? That's why I gave the example. Engaging a guard at my doorstep, telling him to secure me, instead of securing me by 24/7, he's telling that come and sit in front of me so that I will be able to secure you. Then even to go to the washroom, I will have to take the permission from him. Without his permission, I cannot go. This is the inverted form of governance. And this something the citizens should start knowing about it. Because let me tell you, all the AD cases, conviction has to be the 100% because there is no other way out. The moment a 5 lakh rupees is given to me by my client for a fee of filing a SLP in Supreme Court, because I am using that, I can be a money launderer, correct? The ED has to pick up saying that, look here, this money is being given to you by X company, which is against whom we are prosecuting. Since you are also using it, so you are also money launderer, I'll prosecute you. So that means the entire 100% populations are under its clutch. There's no justification in a legalistic sense.
Actually, as you interpret, I think that may not be the intention of the legislature or the government. Only thing is the person who is drafted, maybe they made it so broad-based in order to protect their case. That's all.
No,
I think that is never the intention.
Let me tell you, the original law, the original definition of Section 3, it starts with and as a prerequisite. But now through a 2000 amendment, they have turned it to and to or. Just see that one slide. I'll show you a beautiful slide. The Section 3. It says that whosoever directly or indirectly attempts to indulge or knowingly assist or knowingly party, or just see the top, whosoever directly or indirectly attempts to indulge, knowingly assist, knowingly party, actually involved in any process or activity connected with the proceeds of crime, including its concealment, possession, acquisition, and use. This is one part. And the second part is and. That is a very critical thing. And projecting and claiming it as untainted property shall be guilty of money laundering. This is the definition of Section 3. In other words, if you see the Section 3 originally designed, had two components joined by and. If you can see that and. So, mere attempt to indulge, mere knowingly assist, merely knowingly party, or actually involved in any process or activity connected with proceeds of crime is not a money laundering, unless you project it and claim it as an untainted property, was the requisite at that point in time, originally in the year 2005. But in 2019, through a Finance Act, that and is now turned to or. That means all are independently. That is, concealment is a money laundering, possession is a money laundering, acquisition is a money laundering, use is a money laundering, projecting is a money laundering, claiming is a money laundering. Thereby, every process activity, whether it is concealment, possession, acquisition, use, projection, or claiming, these are all independently money laundering. So thereby, I wanted to draw your very critical question, that if originally it was designing of a draft, I tell you, irrespective of that, what ordinary citizens understand this? Tell me. These laws are meant for ordinary citizens. Now, if the citizens are to be, they have to see the law from their understanding. We cannot educate them after they are acting. Then through interpretation, we say that, okay, you are an offender. So understanding the context is important, but at the same time, what kind of a legislation do we want to address a kind of a problem? Whether the solution becomes problem, this is the problem now. Money laundering itself is a problem. I can tell you, maybe 5 years down the line or a 4 year down the line, this law can't be remain in the book. It is unmanageable. It cannot be manageable. Thank you.
Correct, correct. Like the TDS law in the country now. TDS, so they put all the burden on the payer.
No, but for
no benefit.
your viewers information, I'm the only person who succeeded in challenging the virus of Section 234E, 200 rupees per day TGS fee.
Yeah, yeah.
And the honorable bench is actually presided by the current Chief Justice of Odisha High Court, Mr. Justice Muralidhar.
Right. Okay.
So this every devious element you need to really address through a innovative jurisprudence. Otherwise, if you go by the old jurisprudence, you are not going to address the problem, because these problems are new. The solution also needs to be new. It should be innovative. It should be proportionate. It should be calibrated, and it should be just. It cannot be grandiloquence. It cannot be over elements and all. And the older jurisprudence cannot tackle the new design law. And that's exactly is my understanding of law and my practice style.
Correct, correct. Any other questions, please? I think we are now. It's already 6:30.
Somebody has asked some question, I think.
Okay, please. Please go on, please.
Now Anamika is saying, tell me. Bolo, question to pucho.
How do you compare the criminal jurisprudence in general vis-a-vis jurisprudence of PML?
All right, it's a very good question. And somebody by the name Prabhu
I was not
Prashan.
able to open my video or some other. Now it is open, I think. So
Okay.
indeed, it's a thought-provoking session. We are really happy to have Viswajit sir, who is a trend-setting lawyer and inspiring lawyer for the young advocates in Odisha and Delhi. Thank you, sir. So this question has been asked, I think, by Anamika ji. So I want you to explain compare the jurisprudence of criminal justice system vis-a-vis PMLA. Because here, what I understood that the burden of proof lies not on the prosecution, but on the person who has been accused of an offense.
Yeah, this is actually Anamika read this question posed by. Acha, it is your question, I believe.
Yeah.
Okay.
I was not
Okay.
able to open, that's why I texted.
Okay, sorry. So let me answer that question. See, the criminal jurisprudence that we all know, as you rightly said, that the burden of proof is not on the prosecution, but on the, in this case, accused, right? And that is where this is the new, your legislative policy for the purpose of achieving a particular objective, correct? Now, legislature within its right can always invert the existing jurisprudence. I mean, the different legislative policy can bring about, and this is what is the legislative policy as far as the PMLA is concerned, where the burden of proof lies on the accused, not on the prosecution. Now, how do you see to it? Let me tell you, as far as this particular your burden of proof, which we all know under the Indian Evidence Act and vis-a-vis the CRPC, that is also one separate legislative policy. As far as the general law under the IPC and other laws are concerned. And this is, PMLA is a special law which has inverted it for the reason of the complexity of the situation, because this is a transactional issue. I mean, that perhaps is the one of the reason the legislature must have thought that, okay, we will invert the burden of proof. Now, I ask this question to myself. When the parliament is legislating PMLA, and inverting an existing criminal jurisprudence principle like burden of proof and presumption of innocence and incorporated in a legislation to achieve a particular objective, and then to justify that legislation in an ultra vires challenge before Supreme Court on the ground of compelling state interest, empowers the parliament to legislate a law like this. I ask these questions that does it not create a situation where it rather covers the entire possibility, every particular predicate offense related issue? It doesn't confine to the money laundering. Money laundering is one offense under the money laundering law. And the burden of proof is not only with respect to the burden of proof is not only with respect to the money laundering offense, the burden of proof is also with respect to the proceeds of the crime. Now, as far as the change in policy, legislative policy, shifting the burden of proof and presumption of the innocence, inverting the presumption of innocence. Now, what barometer we need to apply to see that this is just? And let me tell you, I think you understand this comparison under the ordinary general law and then the special law and the legislature giving this inversion to us and justifying it on the ground of the MCOCA and UAPA and your TADA, etc. On the ground of the compelling state interest, where the legislature is empowered to legislate a law like this by giving us safeguards. And that is exactly what the Honorable Supreme Court in the Vijay Madanlal Chaudhary has stated. There are safeguards, and therefore the legislature has done it by using the purposive interpretation. Now the question is this applicable to a case, a gravitational situations like the MCOCA, the UAPA, or it is actually applicable across all? This is point number one. Even if the legislation of this policy justified in few legislation, and therefore those judgments can be cited to justify this legislation, but the distinction has to be shown that there are variants of gravity in terms of the nature of offense, A. B, no amount of a safeguard and not at least the legislative text in the PMLA can justify a legislation of this nature, which actually gone much beyond a mere inversion of the innocence and inversion of a burden of proof, but much beyond the very civility. Because in other words, the state is saying that I will treat you all offender on the basis of my assumptions. You have to prove innocence. And this particular dimension of challenge is never being tested in the law of courts till date. Is it your answer to the question that you posed to me? That is satisfied.
I think this is against the basic principle of law.
No,
Not a
I
single,
thought it is against
not
the
a
civil.
single innocent person should be punished.
No, that is again a legislative policy. That is not actually the rule of law. But we have to develop the rule of law in a different angle altogether. And that is exactly, I'm saying that it has to be developed. It has to be innovated. A jurisprudential innovation is needed to tackle these complex elements, which comprises the every inverted jurisprudential principle at one place. Even though could have been justified for terrorism, but cannot be justified for 420, 415, and any non-complex offense like companies law or income tax law. Absolutely not. It cannot be justified in any manner whatsoever. But anyway, we have to deal with it currently.
Yes, yes. Precisely for that reason, many of the criminal laws of company law have been decriminalized.
Yes, that's right.
So, right. Any other questions, please?
Is there anybody here?
Hello.
Yeah.
Anybody in the audience? Any further questions, please?
I think all are done. I think we can wind up.
I think we should wind up. Yes. Okay. Thank you, Mr. Biswajit. I think one is not enough. We'll have another session or couple of more sessions, to debate on this. I now propose a vote of thanks for Mr. Pradhan, who has been very, patiently listening to the entire proceedings. And Mr. Biswajit, you are a master of this PMLA. And with the authority you spoke, I think you should write something to the government on amendment of the same. Thank you for your time. You are a busy professional. You have given so much of time, so much of knowledge to the gathering. And I hope we'll meet again. Thank you. Thank you, audience. Thank you, everybody.
Thank you.
Meeting comes to an end.
Thank you. Thank you.